вот на этом столе посижу. Потом, наверное, не знаю, дождусь я. Ну, кофе.
Of the forum, ladies and gentlemen, дорогие коллеги,
dear colleagues, dear friends,
panel called Principles and Model Rules of Modern Private Law System of Coordinates. At first, I would like to make a very short introduction, and then the main content of our panel will be, of course, the presentations of our speakers. We have 5 speakers, 3 from Russia, 1 from Brazil, and 1 from Germany. I will introduce them more before the presentations. The main idea of our panel is, I try to change the slides now. Sorry, I can't change the slide. Yeah, okay. During last, maybe said that during last 20 years has been very topical the issues of harmonization of private law in Europe. And first of all, in the center of attention has been, of course, contract law. And if we are talking about the harmonization, there is an official level and unofficial level. Official level, first of all, directives of European Union, particularly in the field of consumer law. The main content is consumer law. We may be said even too much consumer law. And then unofficial level, first of all, so-called model laws. As you know all very well, principles of European contract law, so-called PECL, principles of international commercial contracts, UNITRA, principles of PIC, and then the most modern, most important project, draft common frame of reference, DCFR, модельное правило европейского частного права.
Model rules of the European private law
will be in the main center of our attention during this panel as well. This is a bit strange name, DCFR, Draft Common Frame of Reference. Actually, that draft was started to prepare by the study group on European Civil Code, and the purpose was to prepare a European Civil Code. And actually, this civil code is not correct term because the content is, as we maybe said, that it was a code of obligations. The main parts, general part, contract law, non-contractual obligations, and some related fields. But that was some kind of compromise because, as you know, well, in Scandinavia, in Great Britain, the civil law is not codified, they don't like the codes, and then was find some kind of neutral term called common frame of reference, and it means that the common frame of reference is general principles and model rules of the law of obligations. So the content is the typical general part, then contracts, non-contractual obligations, and some related fields. And what the meaning could be of the DCFR? Primarily, the DCFR is a result of some kind of intellectual result. It has been prepared by the group of leading European professors, and of course the original idea was that maybe it is draft for the real European civil code. It's absolutely clear now that it's unrealistic. But anyway, it's a good source for legislators, for national legislators. And I'm very happy that DCFR has been translated into Russian. One of the initiators of that project was Natalia Юрьевна Рассказова. Она сегодня участвует. She will tell about the possible meaning of DCFR for Russian civil legislation. Now, we may say that during last 3-4 years, the DCFR has not been so much anymore in the center of attention in Europe. That it is clear that there will not be the European Civil Code, but from the DCFR has taken one part, sales law, and now the idea is that, the new draft based on the DCFR, so-called CESL, European Common Sales Law, has been prepared, and it could be more practical as an optional instrument, as a second national law for the countries. Christian Schmies, our panelist, will tell more about that draft. Now, closer back to our panel. What the main topics will be? At first, the meaning of model laws to national legislation at the heading of our panel. In European Union, in outside of European Union, in Russia, Natalia Raskazova, Ilya Nikiforov, Ramanda Toledo will talk on these issues. Some special issues of DCFR, for instance, one of the special part of this are trusts. Svetlana Kolesnikova will talk about trusts. And then after the presentation, at first every speaker will make a presentation on the topic, and then you are free to ask questions. We are flexible in languages, so we can use Russian, English, whatever. And then we will touch some general issues. In framework of discussion, like a question, what could be the other fields besides contract law or the harmonization of legislation that could be important? One of the main topic inside of harmonization of European law is consumer protection. Now we will touch the issue how important really is this and practically is consumer protection in European Union, in Russia, in Latin America, and then we'll deal with some more general principles of the private law, like principle of good faith, principle of party autonomy, principle of reasonableness. And then again, please feel you are free to ask questions, and not only questions, but you may just say yourself what do you think about these issues. Now, our first speaker. First speaker will be Natalia Raskazova. Natalia Raskazova is associate professor of law faculty of St. Petersburg University, head of civil law department. She is a member of committee established for the amendment of Russian civil code, and I may say I know Natalia for many years. She's one of the leading persons in Russian civil law. So, Natalia, please, the floor is yours, and the heading of Natalia's presentation is DCFR как элемент европейской правовой культуры.
As an element of European legal culture and its impact on the Russian legal order. Thank you very much, Paul. I think that my role in the Russian civil law has been a bit exaggerated by you. I would like to welcome everyone, and I would like to thank you for having come here. And I will try to make my presentation interesting to you. And if there are questions, please ask them immediately if possible. Is it okay, Paul? So you can ask questions immediately, not to forget them afterwards. For the first time, I got acquainted with this project about 5 years ago. It is entitled DCFR, but when we translated that draft common frame of reference into Russian, in our slangs, they are called drafts, and I'm going to call them drafts. So I first got acquainted with drafts due to Paul, who was member of the working groups on preparation of this document. And the document made a strong impression on me, primarily from the viewpoint of its legal technique or legal beauty of the document. It would seem that it would be not bad if it became available for the Russian lawyers. And our chair of the civil law, of all the members of our chair, started the work on translation of the document. This work was done free of charge, only on personal initiative of members of our department. And the result has already been presented as a publication, as a book, and it is published in the Reference Legal System Consultant Plus. Thus, it is available to any lawyer in the country. This was the purpose of translating the document. I don't know whether the audience is familiar with the document, but it seems to me that it would be reasonable to address the document for many reasons, which I'm going to mention a bit later. The main conclusions which we could draw after working on the document, and as you understand, we had to read it carefully because translations need great carefulness. First, it is quite obvious that the Russian private law is closely related to the private law of the European states, and therefore we can understand each other well enough. This is, of course, highly important in the context of what is currently called harmonization. Whether it is available, that is a big question mark. But as to the context, legal contexts and globalization, they are really developing and emerging. The fact that transnational relations, legal relations, are also expanding and developing, this is quite obvious. Secondly, doubtless, these drafts embody a modern model of private law. And for Russia, this is particularly important. It happened so historically that we're trying always to keep pace with legal orders of European countries. And under such conditions, of course, if it is good if you have a certain specimen or sample or positive normative regulation. It is highly important. However, I have to tell you immediately that our process when we are trying to keep pace with the foreign legal orders, and we always see that there are certain rules which we really need, and we tried to withdraw these rules from the foreign legal systems. That is a very hazardous process. But inevitably, our minds, particularly those of the young generation of our lawyers who have a free command of their foreign languages, will address the foreign law trying to borrow something from that law, insisting on it. And that is a very hazardous process that I'm going to discuss later. And in this model rules are more acceptable because they offer the result of the supranational legal thought. If you look at the contents of this document, you will see a list of developers of the document. This is a great number of specialists and scientific workers and practical workers from all the countries of the European Union. And the ideas embodied in these rules are supranational ideas. They are free from what often interferes with implementation of the norms of the foreign law under domestic conditions. And thirdly, I should also note that the emergence of the document is an important step towards reconciliation of two non-hostile but two counterposing legal systems, the system of the European civil law and the system of the Anglo-American civil law. We have to recognize now that the process of implementation of the elements of Anglo-Saxon law or common law into our legal system is underway and cannot be stopped. This approximation is quite evident. However, this process has to be directed so that it would take a relevant trend, because we already have certain results of including the elements of common law into our legal system. Just to make this process peaceful, it is highly important to understand the logic on which the common law is based.
When it comes to the document which we are discussing today, because as you already know, the document was also prepared by the representatives of the European Union who work within the common law system. So these elements within the document, I should say, they are included quite subtly in the proposed regulation system, and that's why they become more understandable, especially because Book 10 of these documents is dealing with the subject of trust. So having worked with this book, we gained a clear understanding of what it is, what is trust, the legendary concept for a Russian lawyer. And the last thing, which I think is so extremely important, is that this document represents a professional opinion and professional point of view for the civil law, especially because it's free from any sort of environment. So this is a view of specialists, professionals, of scientists and researchers who were working on the documents, because we're talking first and foremost about model rules. This is primarily what the document is dealing with, model rules that are proposed by legislators as point of reference or a reference framework. So people who were working on these rules, they're absolutely free from any sort of influences and external interests. These people only use their professional knowledge, and their objective was to develop much better the regulation. Of course, everybody knows that our domestic legal process or legislative process is in a very deplorable state. So in order for us to maintain this sense of pride for our system of law, for our profession, I think it would be interesting, if a bit paradoxical for us, to hear the opinion of our colleagues from other countries, whether everything is well in this process, how the laws are developed there, how do they appear? Because when we talk about this country, as I've said, in my personal opinion, this is absolutely deplorable and quite depressing. So in order not to go back to this issue, because of course I can talk about it at length, I have to remind my Russian colleagues that back in 2005, and I'm reminding my Russian colleagues because they do know about it, that at one of the legal events in Moscow, Dmitry Medvedev, who was head of the presidential administration back then, he came up onto the stage and publicly criticized the legislative process. And his proposal was to pass a normative or regulatory document that would regulate how the bill or the draft law is being passed through different legislative bodies to make a very clear and understandable process, which would first and foremost cater to the general public interest and professional interest. So his proposal was found a lot of support, but unfortunately, it still remained just a proposal. And the more we look at it, the worse the situation is becoming with this process. And when we mention the civil code, I see how sympathetically you're looking at me. But when it comes to the civil code, again, this is quite depressing. There are quite a lot of reasons, but right now we're just stuck with the fact that the laws are quite often subjected to a lot of influence, whether they're catering to the interests of a lot of different societal structures and environments, even if they are governmental structures. Usually we are taught in universities that the government does not have its own agenda apart from catering to the needs of the society. So any governmental body does not have its own agenda. But if we do analyze the legislative process and all of the laws that are appearing, we see quite clearly that each governmental body has its own agenda and its own objective. That's what we have in the end. We have absolutely outrageous wording of our laws, which are strange, absolutely unclear. So the latest novel that appeared on the 1st of September, I can tell you that I'm sorry for being so emotional, but I was extremely surprised and taken aback when I learned that from the 1st of September, the management of legal entities such as directors would become representatives of legal entities. Why is it happening? What is the reason for this? We have a tradition of the Russian law, which is based on a lot of classical literature, works of Boris Lipahin, for instance. So, of course, there is always an ongoing debate which exists within the scientific framework, but why are we accepting a norm or a regulation that would completely overhaul or make us revise all of the approaches that have become accepted and traditional? So I think this is one of the problems. Therefore, model rules, they are embodied in a beautiful document, a document that strives to provide much better regulation to cater to the general public interest and the common good. The second issue, which I wanted to touch upon, is what significance, what meaning have the drafts for the Russian private law. I think they can have a lot of influence. First and foremost, they give us an opportunity to actually understand the spirits of the modern European private law. And people who do know this document, I think, would agree with me that this document is based on a lot of principles, dispositivity. This principle is also, according to the opinion of the European specialists, this principle was brought onto the stage. So the limitation of imperative regulation is quite minimal, and I really like one of them. This is from Book 3. This is the regulation from Book 3. The parties cannot forgo the principle of free will. This is very imperative norm, and I think that everyone who is striving to achieve free will in private law would agree to it. So I would say that this is a document that gives freedom and acknowledges freedom. But I can tell you that the freedom of agreement is, or contractual freedom, is based on the free will. And again, one of the leitmotifs that goes throughout the book is that the law only protects a person who is acting based on goodwill. Let me read it out to you. What is it? Goodwill. Book number 1. This is the standard of behavior that is characterized by honesty, openness, and respect for the interests of other parties. And then the behavior that does not correspond to the previous statement, so the behavior of one party on the condition that other party suffer damages because they extended the law of the other party, was not acting on goodwill. Why did I quote this back to you? Was because, and I see the bona fide, I see colleagues who know this discussion, and I do remember how difficult it was for us when we were discussing the concept of improving civil war, and when we were introducing amendments to the civil law. I remember how difficult it was for us to include to the Article 1 of the Civil Code, to include the bona fide provision. There were so many objections, and most objections were related to the fact that if we state that everybody has acts on bona fide provisions, then each judge would be given the power to decide what's moral, what's immoral, what's bona fide, and what's not. So going back to the definition of what is the principle of bona fide. I think that we cannot treat it from the position of what is moral and what is immoral. You know, law is quite a rough instrument. It cannot really take into account all of the moral subterfuges and subtleties. So what is to be bona fide? It means keeping one's word. If you extended the right to the other party to trust in your behavior, then you have to maintain this behavior. So I think this approach to the principle of bona fide will not generate any objections. This is an axiom that is based on expectations. Why do we need a legal form? Because if you promise me, you gave me a promise that my plans will not be destroyed. So I think in this sense, when we talk about model rules, they can be viewed as a document that really reflects the spirit of modern private law. And of course, this is an example of a document which is created using extremely proficient, extremely qualified legal technique. But if you open this document, you'll be able to see it. And why is it so important for us today? Well, because today, unfortunately, the process of creating legislative acts is completely unsupervised, and it results in the acts being written by people who not only have no idea about legal techniques and the language of the law, but even about the legal approach. I can give you a very good, albeit negative example. On the 1st of July, all of us will have an effective law on consumer products. The objectives of the law are great. We have to protect the consumer. We have to protect the borrower. But when we look at the technique that was used in this law, it saddens us. That's why we are usually joking in universities. And how do we give low grades to our students? This law is full of mistakes. The level of legal technique is appalling. Of course, in practice, I know that we'll manage, but again, it ruins the authority of law, the authority of legislators. Had they read a document such as model rules, then maybe they would write laws with better technique and approach. And then again, model rules give us a lot of examples of positive regulation, which I think would be very beneficial for us to adopt. So let me just give you one example. In these documents, this document contains a norm that includes a rule, which I think the older generation of Russian lawyers is very familiar with. This is the principle of cooperation between the parties. In our code from 1964, this rule was formulated directly. When executing their responsibilities, the parties have to extend help and support to each other. Then we entered market economy, and I thought everyone has to cater to his or her own interests. So what sort of cooperation principles are we talking about? Now it only remains when we're talking about construction contracting. So the customer and the contractor should help each other. This is the only example. But the people who prepared this document, they're telling us, go back to the values that you decided to get rid of. And I can tell you that all of the issues and all of the questions that are being touched by the UN, the best thing is not the security, is not the bank warranty, but cooperation, support, and partnership with a business partner. And lastly, the norms of these documents, they have to be used, and I think they will be used in order to interpret commonly acknowledged provisions of the common law. In the first book of the documents, you will find the rules that are being proposed for the interpretation of both the norms and conditions of contracts. I do hope that these documents will have a lot of influence on our practice, but I don't think that it will be done through bills or draft legislation directly. Maybe I'm a bit of an idealist. Maybe this is because I'm a lecturer, but basically this conclusion that I'm about to say is based on my extensive experience working in the legal profession. I think that these documents can wield a lot of influence if it becomes the subject of publication, something that is covered in legal disciplines, in university courses, and it is really worth it. Thank you very much for your attention. Thank you very much, Natalia, for an extremely interesting presentation. So if you have any questions, you're welcome to ask them. I'm really sorry, we cannot hear the question. The microphone is not on, I'm afraid. I'm sorry, we cannot hear the question. Could you please switch on the microphone? I'm really sorry, we cannot hear the question. So, it was just because I was sitting right there. I didn't want to stand up as not to be imposing, but when we are talking about common law, again, it was split into different jurisdictions. So now we are trying to put it back together, unify it, codify it. And here we see a lot of work that is being done by the EU. And having borrowed a lot from the French code and from the German code, I think that's we are also doing something similar, maybe, but don't you think that this is a bit of a reflective? Is it a bit reflective for us that we kind of go back to it? So, having looked into the matter, I thought that was a bit of a reflex on our part. Let me just answer the first question that you have, because my answer will be very short. You know, I don't think that it is reflexive, because, of course, you know, the stylistic, this is something that is being constantly developing and undergoing revolutions. But let's maybe agree that when we're talking about coming up with something new, with rediscovering America, this is unfortunately not possible. Of course, the foundations are there, the roots of the issue are there. But you're right in saying that maybe the conditions of the application of the rules are changing. But I think this is the developments of the same postulate. So when we're talking about the law of jurisdiction being developed, what is it now, in a dead end? No, I don't think it's a dead end. I think that we have to continue to harmonize it, so it is more comfortable for us to live in today's world. Another question that I would like to ask you: you were talking a lot. You were talking a lot about influences and conjuncture bias approach and biases in developing the law. Let me ask you, as a citizen, should law be utilitarian? Or do you think, I'm asking you as a citizen, not as a member of the profession, should law be utilitarian? I understood what you mean. Let me try an answer. I'll try to keep it brief. Should law be utilitarian? First of all, civil law is an applied science, and it caters to the objectives and the needs of today's situation. So I don't know. Remember when I said that we cannot really apply the norms that are being accepted in other countries. We cannot say that the norm that is performing well in Germany would perform well here, because of course we can always implement the norms. A norm is part of our living, breathing environment, and you cannot sort of transplant the environment to another country. And I can say that a Russian entrepreneur would never, maybe someday, but I would say that an entrepreneur in Russia would not work the same way as a German entrepreneur. So when we're talking about law being utilitarian, I can tell you that a norm functions as part of its environment. So let's look at the law that doesn't strive to achieve some idea, but that would perform really well today and in this country and give the result that is really needed by the society.
Interpreters need to remind everyone that microphones are to be switched on. Otherwise, we cannot interpret. No way. And the microphone at the moment is not on. Микрофон. Я учился в Соединенных Штатах, а он учился в
Of German Bar Association, and he's a partner of one of the most well-known German law firms, Hengeler and Müller. And his practice areas primarily are investment law, banking and banking regulatory, insurance supervisory law, capital markets. And the topic, Christian's topics, will be the common European sales law, some policy questions. As I mentioned before, this is really the most topical issue in Europe at the moment. If we look at the topics of the conferences in the various places during, let's say, last 2 years in the civil law area, then maybe 75% of those are namely devoted to the issues of the sales law. Christian, the floor is yours.
Okay, thank you very much for the kind introduction. I'll give you a short overview of CESL, and I'll focus on some policy questions rather than giving a very detailed summary of the proposal as such. Maybe some of this will be familiar for those who are already knowledgeable about European private law, but nevertheless a few words as introduction. The starting point is a status where we have a fragmented harmonization of European private law. There is no European civil code. There is no uniform European private law. And apologies if I talk about European here. It's obviously the European Union or the EC law, so not what we geographically understand to include in Europe. Obviously, there have been many steps to harmonize European law. The traditional method of European private law harmonization was by way of directives. What does that mean? Directives are European legal acts. They need to be implemented into national law by each member state of the European Union. So they don't apply directly in the various member states. Furthermore, European private law has been characterized by sectoral harmonization, i.e. there has been harmonization in some areas, but other areas have remained unharmonized. And important areas of harmonization are consumer credit or the regulation of unfair terms and conditions in contracts. Next characteristic, it's typically minimum harmonization. What does that mean? That means the European directives achieve a common minimum standard, but leave it up to the member states to introduce stricter requirements. That means member states may, for example, typically act to decide to add additional layers of consumer protection. And behind that background, the CESL is rather innovative. The CESL is an optional regime. It has often been referred to as the 28th regime or the second regime, referring to the fact that obviously all member states of the European Union already have their own sales law. And CESL would only grant consumers or citizens in the European Union the option to select CESL as the applicable sales law. Obviously, they could also decide to act under their national sales law. And what is maybe even more important in terms of legislative technique, CESL would be a regulation rather than a directive. What does that mean? Maybe for some of you, it's only a difference in words. For European lawyers, the difference is very important. The European regulation applies directly in all member states, i.e. if the European Union decides to legislate by regulation, no member states can change the regulation, can add anything. It's just the regulation which applies in all member states. So Germany as a sovereign state or France as a sovereign state or whatever sovereign state in the European Union would no longer have the option to deviate from the regulation. The directive, in contrast to the regulation, needs to be implemented by national law. So each of the member states would have to pass its own legislation to implement. That by way of background. Now, CESL goes back to a proposal by the European Commission in October 2011. It's a self-standing set of contractual rules on sales law, i.e. a coherent document covering the fundamental aspects of sales law for all member states of the European Union. The structure of the proposed regulation is listed in the slide. The core are 186 provisions which deal with all various aspects of sales law. And then there is an annex, which is a standard information notice under which parties would agree that the CESL would apply to their transaction. The latest development was a supportive vote in the European Parliament in February 2014. Some of you may know that we had European elections or elections for the European Parliament this spring. A new European Commission will soon start its work once member states have agreed on a new president of the European Commission, which seems somewhat difficult these days. So we are not yet there, it's not yet final, but it's on a good way and it's far advanced. Do we really need a CESL? And I want to distinguish between business to consumer transaction, B2C transactions, and B2B transactions. Despite European harmonization, there's only a limited amount of cross-border trade in the European Union. Only 1 in 10 companies trade in goods across borders. 33% of EU consumers buy online within their country, but only 8% buy online cross-border. And there's an estimate that at least euro 26 billion are lost in foregone trade only because of differences in contract law. Obviously, there are a variety of barriers for cross-border B2C business. You may simply think about logistics. Obviously, it's difficult to ship things from Spain to Estonia than to buy Estonian goods in Estonia. There are differences in language, there are differences in tax systems. So the differences in sales law may not be the most important difference. Nevertheless, the European Commission estimates that the additional costs for a company wishing to target EU consumers in other European countries amounts to 10,000 euro per country. You may think, why don't we need a harmonized European sales law? Would it not be sufficient to select one of the existing sales law of the member states and just I mean, see by jurisdictional competition, which one is best. But the problem with that is that there are limits to competition of legal systems in the European Union. Generally, under European conflicts of laws or international private laws, consumers are free to choose the national law which applies to their contracts. But that is limited by Article 6 of the Rome I Convention, which says that by choosing a foreign law, the consumer must not be deprived of mandatory protection in its own state. So what would be the potential benefit of CESL in cross-border B2C business? Well, first there would be a neutral law, which may make it easier for UK and French consumers to decide on German, or in that case on European law, rather than on French or British law. And with CESL, European traders could apply one set of rules across the European Union. And that may mean that the product range offered to consumers may increase, in particular in small and medium-sized economies, because they could now operate under a European law which may be more familiar to consumers in other member states than, let's say, Greek law or Lithuanian law or whatever law. I mean, obviously, even in Germany, we are not familiar with French sales law or British sales law. There are, however, potential problems for CESL to become popular in B2C transactions. European consumers may be reluctant to agree to the new CESL. Obviously, there would be information costs. They would need to inform themselves what CESL means. And there is already now a high level of consumer protection within the EU. Therefore, it may be irrational to explore CESL as an alternative option for consumers. And then the argument of one set of rules across the EU may be too simplified. Significant matters are out of scope of CESL. For example, questions of representation, lack of capacity, things like that. And even if we have CESL as a common set of rules, it is by no means said that it will be applied uniformly across member states. So it may be necessary to add a special European court system for jurisdiction on CESL to make it really a uniform common sales law. A few words on the need for CESL in business-to-business transactions. I think there are significant differences in the case for CESL in B2B transactions. The different legal systems may be less important in B2B transactions. In fact, the International Chamber of Commerce in 2012 said that the difference among European systems of contract law is not a significant problem for cross-border trade in B2B transactions. There are less restrictions for competition among national laws in B2B transactions. Commercial parties could freely choose the applicable law to govern their sales contracts. And already now 23 of the European member states are contracting states to the United Nations Convention for the international sale of goods. So where does that leave us? I think one should not underestimate what I call the intangible benefits of CESL or epistemic benefits of CESL. CESL has spurred a multitude of research, publication and conferences, strengthening the pan-European legal discussion on contract law matters. There are now pan-European commentaries written on the CESL, and CESL may well be something like a legal toolbox for other European areas of law, but also maybe for other jurisdictions as model for own legislation or as a chosen law in international transaction. And it's certainly wise to make it a first step to mandatory harmonization, maybe at a later stage. Resistance against the European civil code is still strong within member states, and European harmonization has always been a story or a history of small steps which may ultimately lead to bigger results. So I think CESL is a good starting point. Also to strengthen European identity among the member states. And even if it will still take years to really develop a common European sales law, I think it's important, especially in times where also in Europe legislation is very fast, often not well prepared, and then it's good to have leading scholars both from outside and inside the European Union to work on this important project. Okay, that was it from my side. Thank you very much.
Thank you, Christian, for a really interesting presentation. Now, if you would like, then one question. We have 3 more speakers. We are a bit under the time pressure. Okay, if no, then later on, I hope we'll have time for additional questions. And now, the next speaker is Ilya Nikiforov. I have always admired Ilya, that how one man is able to do so much as he does. He's managing partner of the leading Russian law firm Yegorov, Puginsky, Afanasyev and Partners. He is teaching at the university civil law. He is internationally active. Belongs to the group of leading litigators in Russia. He has several areas of professional interest where Ilya is well known: intellectual property, international arbitration, litigation, and so on and so on. So, Ilya's topic today is взаимодействие lex mercatoria в отечественной правовой системе. The floor is yours.
Я буду говорить для переводчиков по...
I will speak Russian. And here is my presentation is on the screen. Indeed, I was thinking of how to define the topic of my presentation. And in the Russian panel, I would have said observations about the ontology of the model documents, private codifications, instruments and the documents as instruments of direct democracy. And I observed the forms of life of the documents, so to speak, which are not norms adopted by any national or supranational bodies, nonetheless have a regulatory impact on the system of public relations. And I would like to share these observations with you. And there are 3 hypostases of those, 3 levels of their existence: through laws, through legislation, through judicial practice, and through the everyday practice, the everyday life, and the settlement, not of the conflict situations, rather the practical situations that emerge in the private sphere and commercial sphere. And there was a phrase about the green man. So if we build them, they come. If these green creatures might appear. They appear at the end of the film, but in Russian we also have an equivalent. If there is a holy place, it's never vacant. So a few words about direct democracy.
So some words about direct democracy, and it is already a joke, recalling the presentation by the Swiss colleagues who have great involvement of the citizens because of the country is not so big and lawmaking activity is quite popular, and very many regulatory acts at the federal level are adopted by the voting, by the referendum, not directly by the deputies of the parliament, and they are approved by the cantons, and representatives of the cantons are then voting for the most important national acts, that is the common procedure. And commenting on it, my acquaintance, a Swiss lawyer, said, "Do you know where babies come from? Germans say that they're found in the cabbage, and the French men say that they are brought by the stock. And in Switzerland, that depends on the particular canton." Thus, my first statement, the form of life via the national laws. It is not a secret that the best-known private codifications, and the first of them was the European codification. Just ahead, the rules of international agreements, UNIDROIT, appeared in the first wording in the 90s. I think it was in 1994, and they were quite helpful for those who compiled the first version of the civil code. And these people are even present in this conference room, and subsequently in the course of revision of our civil law, the concept of reforms of the civil law, which existed for several years, often corroborated the necessity of revision and legitimacy of the amendments proposed, not with references to the foreign law, but to the type document UNIDROIT principles that is purely a private codification. It is interesting to note the practical aspect, and being a practical person, I always think that we have to take into account the practical aspect as to what is its significance for us in our daily life. My history is dated by 1997. I am a young teacher at the law department. I have Russian students in my group as well as foreign students who also are trained at the law department of St. Petersburg State University. And we have different practical workshops, and one of our tasks is as follows. A young person, a teenager, one was a winner in a lottery, and how, due to restrictions, due to his legal capability, who is not yet adult, how can he dispose of that prize? And we have to interpret to the student the civil code, which appeared 2 years ago, the phrase how to dispose of a different revenue. If that prize of the lottery is at a different revenue, the students were studying the civil law for 2 or 3 months, and my German student was also trained in Russian. Everyone proposed his own version, and the most correct version is presented in one of the rare publications. These are comments to the civil code. There were 3 or 4 publications, and one is a rare publication. So the German student stood up and proposed the statement that was similar to the interpretation of the civil code. We agree with him, and after the classes, I asked him, "You don't have a good command of the English. How did you manage to find that rare book and to find the statement?" "I have never found that book," he said. "That is a poor translation of our civil code in Germany, but instead of the term of revenue, we don't use the term of any increment of personal property, but an increment that show that was obtained by a person in his own way, even in respect of borrowing from the model documents that which our legislators have taken. It is quite often to address to the source document as to how it is used in practice in other laws, because it might be quite a good support from the practical viewpoint to determine the practice or application or interpretation of novelties in our law. The second form of life via the courts of laws, this is a resolution taken in 2005, the decision taken by St. Petersburg Court of the First Instance. And in this dispute, the problem that was quite important for national justice, the problem of proving the losses. We often our courts of law often used a mechanistical approach, and no losses were compensated if there was a slight error in calculations, for instance, in copics, and then you won't get any compensation of the revenues. A unidroit principle was applied at that time that allowed the standards that are inherent in the present wording of the civil code, then that now was not existing. They permitted a reliable degree of reliability. So neither the northern route nor the cooperative that was Lengas had any relation with foreign states, and the question was payment for the energy that was provided or that was supplied. However, the judge of the arbitration court of the first instance applied the provisions, applied the unidroit principles, and her decision even reached the higher arbitration court. They didn't mention it in the resolution of the plenary session. They didn't mention unidroit provisions, but they said that the Judge Kapilova was quite right in her court decision. Similar precedents were also recorded in the practice of the latest evidence. I don't know whether Firm VARUL knows it, but 3 judges confirming their position concerning the submission of the case for consideration by the higher arbitration court, referring to the common frame of reference. And finally, this slide is in English, my apologies. In my favorite sphere, in the sphere of international arbitration, there is more private codification that is adopted by certain public organizations acting in that sphere. One of such organizations is the International Bar Association, IBA, the Committee of International Arbitration, and 4 documents which are also translated into Russian. And being a vice president of the arbitration committee of IBA, I personally participated in drawing up these documents. These guidelines on party guidelines for drafting international arbitration codes, and the latest developments, the guidelines concerning the behavior of the parties in international arbitration. Thus, probably that slide has been omitted, but I'd like to tell you that even such private codification as the testimony taking of evidence in international arbitration was taken as the basis by our arbitration court when they solved the question concerning the elimination of the ruling of the arbitration court, whether the arbitrator was impartial. So they took that private codification IBA and analyzed the specific situation, and with reference to this, the decision was passed. Thus, probably private codifications are reflecting common practice, and sometimes they might be partly the purpose formulating document, de lege ferenda. In the absence of the law, something is being formulated in them, and this is already used in life. But I know for sure that in the international community, currently 2 documents are being compiled in the sphere of arbitration concerning the expenses on international arbitration and compensation of the expenses and confidentiality, degree of confidentiality in case of disclosure of the information. And the compilers really have the pain in the neck by inventing new terms. Probably that was a very good draft common frame of reference, but the chronology is like that. The first document which is currently present in the wording of 2010, but historically it was named the rules on the proofs, and they saw that this was not meant for mandatory use, and that was a debatable document, and that a list of rules provide so that the parties could get any rules out, and that becomes the last instance. And the next document on the conflict of interest in international arbitration received a softer name. These were not the rules, but the guidelines on conflicts of interest in international arbitration. And all of a sudden, quite often the courts and in the international arbitration procedure, that is a rather soft document that was planned for home reading by the arbitration community, and it is used as a regulatory act. So now we are searching the names for the new documents that will appear about the expenses and confidentiality, because these are not model rules and not guidelines, but this is something like notes on this theme, and probably they will be entitled new notes on the theme, and the parties, if they want, will be able to incorporate them into their regulatory agreements, into the arbitration procedure, and if they don't want to it, no one will impose it on it, neither the arbitrators nor the national courts. And the last item which I would like to discuss, the form of life, of daily life, of these model documents. And crowdsourcing, my discovery in 2013, crowdsourcing is a concept which into Russian can be translated as capitalization of mass resources of the masses. This concept was described to me by a colleague who was not a lawyer, who works in a different sphere, but it is quite universal and applicable, proceeding from the fact that each person wants to do something good, being a benefactor that is based on the benefactor's main quality of human nature, and then he wants to share something. However, from the viewpoint of competence, the concept consists in the following. Broad circles of population, for instance, those who are present in this conference room, individually have more competence and more ability to do something than a specific individual in that sphere. For instance, to repair a car, if you take a piece of knowledge from each person, that can be done together. If that knowledge is collected into it is integrated, and that will be done better than probably a mechanical engineer from the car servicing station. It will be done adequately and without any mistakes. Why does it not happen? The secret of that crowdsourcing or capitalization of resources of the masses consists in the following. The problem is related with tools. We need certain tools or instruments to bring together in a good format using the statement by Andrei Rybalov. We need a conceptual framework so that everyone would add their knowledge to that framework, and those who can use this knowledge will do it easily at the hand's distance and take this knowledge. Concluding my theoretical part, for instance, this can be exemplified by the fact that having this knowledge when selecting the candidates for training at our company, we offered them to draw a picture of reverse acquisition. There is an instrument of corporate combination or corporate restructuring that is reverse acquisition, which sometimes is suitable for the customers, but I cannot explain to you or to the customers within 50 minutes what it really means. Therefore, if you cannot use proper words, you can draw it. And we were checking these drawings and we analyzed the talent of our candidates. It is a very interesting job when we were looking at these drawings and pictures. How did we invent it? We just read how outsourcing projects were working. However, for the model rules, will you please look at the screen? That is a Vicurus project in which I participated for our sphere where the lawyers work with text for modern information technologies, offer a more convenient instruments, primarily the information systems, sites and internet portals based on the same technology and on the same software as the well-known Wikipedia Encyclopedia of Free Knowledge. We have created such a resource dealing with the practice of application and interpretation of arbitration rules. UNCITRAL, it operates in English and in Russian. It is free of charge and it is supported by those who are interested in the international commercial arbitration. It seems to me that other model documents in such form can be also put on separate shelves. Why have we chosen arbitration rules? UNCITRAL, it is so to say, it hasn't any own. Of course, there's a international Commission on International Trading Rules of UNO. I also participated in drawing up the text of 2010. Unlike other arbitration institutions, they promote it for establishing it, but as for selling it, as for advancing it, no efforts are taken by them, unlike many other arbitration institutions.
Institutions which travel throughout the world with the lectures, which do a lot of publications and markets their services. That's why we saw that there was not good commentary to the UNCITRAL, either in Russian or in English. So when the project was started, nothing was there. That's why we decided, let's publish an online commentary, which would be developed through crowdsourcing, through everybody who wants to participate. That's why when you look at each article, you see a conceptual framework. Each article has the actual text of the article, then it has a unified table that specifies adjoining regulatory acts or other documents, or in our case, it's the IBA rules. We also have standardized forms, so if you're talking about the appointing of arbiters or submitting an arbitration appeal, we provide the forms. There is also commentary, which is the text, the history of the developments of UNCITRAL framework and the judiciary practice. And what's more important is that everybody has an opportunity to say their words, to add the commentary, to add a precedent. So it's really easy for the user. It's as easy as editing your page on Facebook. And the second thing is also based on the crowdsourcing principle, which is quality control, the output quality control. Just like in Wikipedia, people make their contributions, they introduce amendments, changes or additions, and then their peers, which are selected by the computer system, they review all of the changes and amendments and make sure that they are reasonable, correct, and justified. So I think that this format, so that this system would be very interesting. I wanted also to show it to Paul for the draft common frame of reference, so we can probably also utilize this resource and to see how it is being used in practice, so you can actually get news from the battlefield, so to speak, so that you can receive proposals for changing and amending the text. I'm pretty sure that it will be quite successful, so I do urge everybody to visit the portal, to visit the website, and for DCFR, if you build it, they will come. So if this project appears, I think it will find a lot of support. Thank you very much. Thank you very much for an interesting presentation. I just have one question. No, everything was clear, no questions. Then we have two more speakers today. So I do hope that we will have enough time left, should you have any questions.
The speaker is Armando Toledo. Armando is experienced judge from Brazil. Of course, you may ask some question later on football issues as well, but at first he will talk about developments of law in Latin America. Armando is justice at the Sao Paulo Court of Justice and special assistant to the president of Sao Paulo State Court of Justice. To understand what's the level of the Sao Paulo Court of Justice is that it's enough to pay attention that how many? 20 million of people, of inhabitants in Sao Paulo. Sao Paulo, it's in the city of Sao Paulo.
40 million.
Yeah, in the state, 40 million. It's bigger than many bigger than most of European countries. It means that Armando is really judge of a very high level. And I'm happy to give the floor to him.
Good morning, Mr. VARUL. Good morning, the respectable and dear speakers. And in my left side, Rodrigo Carcelhan is a lawyer in Brazil and my support in English language here. Good morning, ladies and gentlemen. First of all, it is necessary that we do a brief distinction about the topics that will be discussed here, such as the differentiation between public and private law, as well as the distinction between principles and rules. The first division held between public and private law was held by the Romans, making use of the criterion of public and private utility ratio. The first referred to the properties of the state, while the second was related to the individual interests. However, for today, this distinction has become scarce, requiring supplementation. Therefore, we will be dealing with private law when the contents or subject matter of the legal relation is immediate and the particular interest prevail, and when the shape of the relationship goes by coordination. Made the distinction between public and the private law, now we go for the differences between principles and the rules. We know that law is expressed by norms, and these are further divided into rules and principles. Rules will discipline a certain situation. According to Canotillo, rules are norms that prescribe a mandatory requirement that is or not met. Principles, in turn, are general guidelines of a legal system, and its spectrum of incidence of much broader than the rules. Completed the necessary distinctions, we can address more clearly the topic in question: principles and model rules of modern private law. As time goes by, the private law has placed a prominent role in modern society. It was formerly the public law that prevailed in relations, and these, almost in its entirety, get along with the state. The new economic order from the ongoing process of industrialization and the growth of commercial activities has left the state in the background, emphasizing the legal relationships between privates. This new scenario has created the rules about private law. In the Brazilian case, we observe the creation of several codes that deal with matters such as the 2002 Civil Code, the Commercial Code of 1850, and the Consumer Protection Code 1990. Worth mentioning that our Constitution also deals with matters of private law in order to satisfy the public interest in private affairs. In those texts are written the principles and the rules relating of private law. Obviously, this compilation of rules may vary from country to country, depending on the particularity of the national laws, as well as a differentiated understanding of the courts. However, we can list some common principles to all, considering that the character of private law is similar to all. Among these principles, we can mention principle of personality. Every human being is the subject of rights and obligations for the simple fact of being a human. Freedom of choice. The recognition that the general legal capacity of the human person gives them the power of performing certain actions of refrain from them, according to the dictates of his will. Other, freedom of negotiation stipulation. This power includes the power to grant rights and accept duties, inaugurating legal business. Other, individual property. The recognition that man, for his work or by other ways that the law contemplates, can externalize his personality in real or personal property which become the exclusive object of its desire and its assets. One more, family phasing. The notion that between legal situations constituted by the free will of individuals there is on that is the immediate expression of his personal being. Legitimacy and inheritance and the right to test. The acceptance that among the powers that man exercises over its assets. It is included the power to forward them in whole or in part to his heirs, starting from descendants. Given this exposure, it's clear to us that the main peculiarity of this branch of law is embodied in the autonomy of the will, unlike what occurs in public relations, where one party is in an advantageous position over the other, and therefore carries some degree of coercion. In particular relations, which, as discussed above, present coordinates relations the manifestation of the will is free. For sure, this is a scenario that can only grow due to the rapid speed at which globalization affects society. The relationships between individuals will also be widened, whether in commercial, contractual, or equity framework, when a nation opens its door to another. In order to establish relations with them, the normative conflict gets evident. These relationships are more latent in the field of commercial law. To enable a country to sell its products in this territory or otherwise, we shall settle the so-called institutional advantages. These advantages are due to the laws of each country, which may favor particular products relative to its competitors. For the abolition of those institutional advantages, states have been negotiating and signing international agreements, such as JATT, General Agreement on Tariffs and Trade. From these agreements, we can extract some principles of international commercial law. 1. Most favored nation clause. By this principle, no state may grant products sourced from another state and benefit not awarded to the same extent to products originating from the other participating states of the treaty. Other national treatment. By this principle, the law should release the products manufactured locally and imported, while similar equal treatment. One more, suppression of dumping. When a business company sells its products in a foreign country for less than what is practiced in their own country, this practice, dumping, distorts free competition and therefore must be suppressed. However, those measures alone do not achieve the desired goal. Another way found to minimize this institutional advantage is the so-called social clause. As we observe, a greater concern with personal relationships and their specific regulation. We also note that, in parallel, the care for the human welfare is constantly increasing. The private law did not remain inert in this regard, and therefore, it was agreed that the liberalization of global trade depends on the concomitant rise in the standard of protection towards human rights and the environment. Therefore, properly respected the human and environmental rights are fulfilled the social clause. We observed that globalization requires high standards. There is a civilizational standard in central democracies of the capitalist system, serving as a target to be achieved by any country interested in becoming part of the globalized economy. In relation to South America, the current global situation, where there is a process of overcoming national borders in the development of states, allows and forces a regional integration. Brazil and other countries geographically close are involved in a process of economic integration that was named Southern Common Market, Mercosur, under the Treaty of Assumption 1991. The countries that originally signed the treaty are Brazil, Argentina, Paraguay, and Uruguay. This from the bloc was initially characterized by being a free trade area. There, members of the Mercosur mutually undertake the commitment to eliminate existing tariff barriers on its borders for goods produced in other participating countries. In addition, Another concern of the bloc is called transposition of non-tariff barriers, such as economic, administrative, bureaucratic, and even cultural factors that affect the bloc goal. Therefore, standardization of bureaucratic procedures, customs stamp required in the different countries members of the anti-dumping discipline, roles of sanitary control, among other required. However, Mercosur can be considered, since December 31, 1994, an imperfect customs union. Admittedly, the Assumption Treaty provides that, on this date, it would be deployed common market, pursuant to Article 1. And we cannot consider it as a simple free trade area, since it is already deleted the certificate of origin for domestic products. The Mercosur Customs Union can be classified as imperfect due to the numerous exceptions to the common external tariff. Fact is that the members of this bloc still have difficulties to achieve the initial goal. The strengthening of Mercosur depends on the deepening of the integration process. Now, integrate here also implies in matching law. The Assumption Treaty mentions the commitment of its members to harmonize their laws in relevant fields for the strengthening of the integration process. In this framework, the free movement of goods and services, as well as individuals, would result in the need for changes in civil law, including chapters on the right of personality, family, and succession. Consequently, those responsible for those actions should be attentive to the driving principles and the rules of private law. As much as this harmonization becomes necessary, it should not stand out to existing foundations. The law must find a balance between a strong capitalist nature that involves the particular relations and the growing need to respect the rights of the collectivity. Based on the foregoing, it is evident the greater importance that is being given to private law. This branch of law has denominated relations in society because of the nature of capitalist globalization that affects the vast majority of nations. Therefore, it is inconceivable that we give such importance to private law without observing its principles and rules, while we move towards a society that emphasizes freedom of choice and the parity of the pools of the relationship as essential for proper development of this matter. We should not forget the public interest. This is what is being advocated in this new coordinate system, along with the elevation of the ruling concerning the private relations, must coexist the protection of the collective interests. It is expected that the states enter into harmony so that these objectives are achieved, considering the need for them. Today, the interactive and the globalized world is a reality. To adapt to it is necessary that we adapt effort so that together we can properly regulate our relations, observing the requirements of both individuals' needs as society needs. Ladies and gentlemen, briefly, thank you so much.
Thank you, Armando. Very interesting presentation indeed. Do we have questions? One question is allowed now.
Well,
yeah? Please, microphone.
Thank you. I would like to know, as I know in Brazilian civil code, you have some principles principle of social interest and principle of solidarity. According to this principle, Brazilian courts could change the norms or the positions of their contracts. I would like, if really the Brazilian courts during the court proceeding change the positions of the contracts, does such principle work in Brazilian courts by such a way?
Não, ele está perguntando o seguinte, se a Corte Brasileira pode alterar contrato pelo princípios gerais do Código Civil, se pode alterar uma coisa que está contratada.
Pode alterar desde que no contrato demonstre uma desigualdade entre as partes e cláusulas que prejudiquem uma em prejuízo da outra.
Se for, posso falar com relação ao consumidor?
Pode.
The justice saying that if you were talking about a relationship regarding the consumer, and then
only consumer,
a consumer, and then there is a high difference between the obligations on the contract. The
but
court
if it's a commercial contract, it doesn't work.
Com relação ao contrato comercial.
Sim, se existir cláusulas que causem desequilíbrio, o magistrado modifica, sim.
If there is a very high difference between the obligations, the court can intervene.
But it could be.
It could be.
Thank you very much.
Yes, okay.
Yeah. Thank you. Next speaker is Svetlana Kolesnikova. Svetlana has graduated from law faculty in St. Petersburg, and she is really experienced judge. She has served as a judge from 1991 on the various courts. And since 2009, Svetlana serves as a judge of the Federal Arbitration Court for the Northwestern region. At the same time, she is preparing the doctoral thesis on trusts. And trust, as you know, it's one of the part of the DCFR, and this is a interesting issue. Why the trust are the part of the DCFR, which was planned as a civil code. And, you know, this is some kind of compromise between continental lawyers and lawyers of Great Britain, because lawyers of Great Britain, they did not like the code. And that was a compromise. Okay, let's be the code. At first, that was named as a European Civil Code, but with the trusts. And for the continental lawyer, this is a really interesting issue, what the trusts are. And the heading of Svetlana's presentation is on
the prospects of the development of the model principles and rules of the European private law on trusts in the system of Roman and Germanic law. I will speak Russian. We can speak about the aggressive expansion of trusts. This term is sometimes used, and this aggressive expansion of trusts make practitioners and theoreticians speak about trusts quite a lot. We have to speak about trusts because trusts, I'm talking about trusts because there are many different types of trusts. And I'm going to use the single form, talking about trust as a notion containing all the major characteristics. My colleagues keep asking why a judge would be interested in trusts. You probably do not have this practice, but allow me to speak about the practice and explaining why I have been working with trusts. Mauricio, as any other Italian researchers say, if you want to know what trusts are, you must really try to go deeper than you are planning to. 12 years of experience, and still I can't say that I have reached the limit of my knowledge. No, trusts keep developing as well. So what is the practice? Where would the trust regulations be used? For example, there is a traffic accident case, and a third party is the father of a woman who is the owner of the car, and her husband was driving, and he says, I have the power of attorney to the son-in-law, but you are still the owner. So he wanted to get rid of the burden of property. At the same time, he doesn't trust the son-in-law, and the daughter is afraid to lose an expensive car. So just in case, he issues the power of attorney. And so there was a need. He wanted to get rid of the burden of property, and at the same time he did not want to give the power to the daughter. This is the case of a car, but these could be shares of a big company, any other type of business. Then an elderly person gives as a gift a donation to the grandson an apartment. That grandson is a very weak person, and she decided to leave the apartment to him, for him not to be deprived of the apartment when she dies. But he had very bad company. He had a lot of debts at a later stage, and so she goes to the prosecutor's office, and she wants to protect her apartment, but there is no way to recognize this contract void. There are no legal grounds for reversing the situation. Had this been in the situation with trusts, then of course the protective trusts would have been used, the way Princess Diana left heritage to William when he turned 30. And the property had been taken care of. There was profit taken care of properly. Now, if you go from general jurisdiction courts to the arbitrage courts, and the first generation of wealthy people, beginning with the economic reforms, is leaving us, so to speak, dying. They're getting old, and this is happening everywhere, not only in Britain, but here as well. So there is the problem of inheriting business, of imagine a situation. A big businessman, an important businessman, was married twice, and the relations between the two ex-wives are not that good. And how is it possible to organize a meeting of the shareholders who both have votes? And then there are also children. One has a minor, a child who is a minor. The other one has an older child, and it's the second wife who inherits, and her baby. But the older daughter, who is an adult, wants her mother to become a trustee. And she is appointed a trustee. That actually means that over the first 6 months, nobody can dispose of the property. But then she organizes a meeting. She has 50% from one heir, 50 from another one, and she changes the statute, the charter, and the correlation. So she has 50%, the remaining 50 are divided by 3, and she is able to alienate all the property that had belonged to all the others. So the business cannot work at all. Actually, there is nothing left in the company. Then there are numerous litigations, and then another child emerges, so to speak, an illegitimate child. And then there is the discussion of the right of this child to inherit. So the business is not there any longer. The business is not going to survive all this litigation. Thus, these fights between the heirs might ruin any business, and that is why many of the businessmen are now taking their business out to the countries where the trust law acts, in order to protect their business, in order to leave it safely to the next generation. Now, when we talk about trusts, they would say, oh yes, that's tax avoidance and offshores. it's not the best part of the trusts. Well, the best side of the English trusts is the ability and the capacity to return assets and to keep assets in the family. Of course, there are family trusts, there are commercial trusts. If we take a family trust, something difficult for us to accept. Just a few words. Why do we need the family trusts? And if we talk about the International Financial Center, then we must understand that a certain freedom is required, reason of the disposal of assets. No other mechanism is as competitive in the market as trusts. So in commercial aspect, trusts can be extremely important, particularly since trusts act in South America and China, adapted trusts, of course, adapted models, but still they are there. They all borrowed as much as possible from the traditional English model. Now, let's look at how this model can be adopted here. When I read what the young researchers write about, and I can see that some say that trusts should never be borrowed. Then others say it should be borrowed as an element of the substantive law. So some of the researchers suggest a test for the students, typical of Britain. If they take this test, then they can talk about the system. Indeed, it's a whole field that is regulated by the equity law. And if sometimes the equity law is mixed up with common law, trust is regulated exceptionally by equity. Trusts are exceptions in any system of law. Let's start with the fact that in Britain they also emerged as an exception. The common law that existed in Britain did not recognize trusts. It's a romantic story. A knight would leave on a crusade, and land was given only to those who could fight. Only men could inherit. So he would leave land in trust with somebody else. I am away, and you are the owner, or you are considered to be the owner of this land while I am away. If I do not come back, then in 10 years, when my son grows up, you give the land to him. The knight was killed, and then the trustee did not follow the obligations, and the chancellor, representing the king, could not be happy with that unfairness and gave orders which acted against each particular individual. You are responsible for this house, for this land, and you are supposed to give it over to the son. And so from the orders issued by the chancellor, the equity law emerged. And one of the reasons that prevents the adaptation of trusts in the Roman and Germanic laws is the absence of the equity law. So how much typical is that in light of the principles that we have today? And I'm going to talk about the model rules, because the model rules, and I would really like to thank the working group because they, out of all the numerous groups, and I'm actually observing the work of all the groups who work on the trust models, have come as close to the English model as possible with the equity law, and technically they have managed to render all the major trust characteristics that make it so competitive. And so to get rid of some of the mist that envelops trust, allow me to give you some examples of maxims. Maxims are the major principles of the equity law. What makes them different from the Roman and Germanic system we have? Because these rules existed for the judges. They gave instructions to them how to make law. So the policy was defined by them. And by equity, each dispute is specific. Let's take there is a dispute between the oligarchs. You are all aware of that. For over a year we were watching that. And these were trusts. And this particular case actually was a test of the honesty of the trustees. And in each particular case, a judge follows these maxims. The first maxim reads, equity will not suffer wrong to be without a remedy. So that's how the trusts emerged. You promise to hold the land and you do not hand it over, and then the chancellor applies remedies. The next maxima, equity follows the law. Since there are different spheres, there is the common law, there is equity, those rights that are guaranteed by the common law should be recognized. So if there is a trustee, then you own, but by the law of equity, you must follow the fiduciary liabilities. The equity does not allow a statute to be made an instrument of fraud. Actually, this complies with our principle of the impossibility of the abuse of the right in the respective articles of our codes. And there is a similar norm in all the legislations of Romanic-Germanic system. And the first article of the code now speaks about the principle of bona fide, which correlates with the modal rules and the principles contained there. There is an absolute correlation here in that. And so in the absence of the principles of bona fide recorded in law, the judges are still applying this code. If you go into the database and look for the word dobrosovestnost, bona fide, you will find a lot of judicial acts because the Director General should always act in this spirit. The executors, the governors, and so if and the managers, because if one of them allows alienation of the property entrusted with him, then it's abuse. And well, of course, the bona fide principle should be observed by the other party as well. How much time do we have? I need about 5 minutes. Well, I would rather answer questions because the topic is very extensive. Even 55 minutes is not enough for me to share what I would like to share with you. So I listed some of the maxims. There was one very interesting maxima. Why did the oligarch lose in London? Do you know why? Because there is another maximum. The one who goes to court should go to court with clean hands, so you should always act honestly. If you want to get money violating law, then you are not going to get the protection by the equity law. Again, it's according to the maxima. The judge of the Constitutional Court, Yaroslavtsev, who spoke at the conference, related to this maximum. And he spoke about a particular case when a person was fined by the Anti-Monopoly Committee for 300,000 rubles, and he went to the Constitutional Court. The court, by administrative code, could not really appoint a fine any lower than the one appointed. And the judge was against that decision because they were not acting in the spirit of bona fide. When the Anti-Monopoly Committee was expected to present the documents, they didn't do it, and he wanted to find a judicial remedy against that fine, and so there was a violation on both sides. So that's concerning equity, and then fiduciary liabilities. They say we don't have them, so we cannot borrow trust, but that's easy. I think all the lawyers know about fiduciary liabilities, and the practice of the arbitration courts is full of the bona fide honesty and so on and so forth. And with the model principles and the model rules that are in the drafts make it possible for us to say that the modified model can be taken in by us from the point of view of the equity law and fiduciary rules. But we have a systemic barrier. So these principles should be divided into technical and political and legal. Political and legal principles are the same. But as for the technical ones, then the major barrier is the title. Who is the owner? And the model rules do not settle that. And no one and nothing can settle that, because trust is exactly that type of relationship. We can say that in San Marino, let's say, they say that it is a delayed gift. A son says, here I transfer it to you, but not at the moment, with a delay, when you turn 30. Until she turns 30, there is no complete owner. And this is impossible from the point of view of the concept of property that is contained in our civil code. And what is the code? We define all the types of relations and obligations. And how can we define them? If we define them, we limit them. And trust cannot be limited because trust keeps developing. Trust is easier to describe than to define as an elephant, let's say, because, well, this elephant might be in a store breaking quite a lot.
Therefore, what was mentioned by Natalia Yurina, we cannot transfer the environment, so we have to work on it, and we're going to proceed in future. But as the Mr. Zorkin, chairperson of the Constitutional Court, states that has to be done gradually. We have to form the environment and the norms. That was brief information. If you have questions, you're welcome. Thank you very much, Svetlana, for your interesting presentation. And now, if the theme is interesting, time flows quickly. But still, if there are any quick questions, we can ask several questions.
Yeah, thank you so much for a very good presentation. Really nice.